that took some of us by surprise, because usually the practice is that when parties to a matter before the courts file applications supporting affidavits and affidavits in opposition are filed, the courts will normally allow the parties, the applicants, to move the application, and you hear the lawyer say, we move, or I move, in terms of the motion paper, the supporting affidavit, and exhibits. And the court then has a discretion to allow you to add a few oral arguments or to stop at the moving of the application. The court has that discretion. The rules of court and precedents are very clear on that. But today the applications were not moved as the norm is. The trial judge said that what had been filed and were before her were adequate, and that she was going to deliver her rulings on these processes. It is not any substantial matter that we are going to move on something else. At the end of the day, the trial court has that discretion, exercise that discretion. Just that we, as a party, would have been happy, given the considerable public interest in this matter, if at least the application had been moved and brief oral arguments in support and in opposition had been heard. At least it would have helped in educating the public about what these processes the courts refer to are. But be that as it may, a decision has been made. The matter has been adjourned to Thursday for a ruling. Not only of the 4 applications that are currently pending before the trial court, but also an objection that counsel for Mr. Gyamfi has raised. For those who may not be aware of what these applications are, the first application has to do with an application for stay of proceedings relative to the decision by the court for counsel for Mr. Dr. Atufosin, first accused, to cross-examine the third accused first before the prosecution does so. So that the sequence of that cross-examination is one that is being challenged. There is a stay of proceedings in relation to that, and it is one of the matters that the court has indicated it will be ruling upon. The second one has to do with an application for the termination of the entire proceedings and or stay of proceedings by Mr. Gyamfi and his lawyers. This application, I'm sure you've seen it in the media. The affidavit in support was sworn to by Mr. Gyamfi, third accused himself, and he speaks to several interactions he has had with the Attorney General, Godfrey Adame, in which the Attorney General told him that he knew he was innocent, but he needed to add into the suit to camouflage his real intentions, which real intention, according to Mr. Gyamfi, was the persecution of Dr. Atufosin, the minority leader. And Mr. Gyamfi goes on to say in that affidavit certain comments that the Attorney General made in those interactions that border on clear professional misconduct, prosecutorial misconduct, and criminal conduct on the part of no less a person than the Attorney General. He has attached the audio recording that we, the NDC, have already played through the press conference we did, at the press conference we did last week, and has indicated to the court his willingness to be cross-examined on that evidence. So that, in summary, is one of the applications. There is another application from Mr. Atufosin and his lawyer, and a supplementary affidavit, which is also seeking an order for mistrial and or stay of proceedings on the basis of all these issues bordering on prosecutorial misconduct, professional misconduct, and criminal conduct on the part of the Attorney General. The summary of the depositions are basically that the Attorney General has set out to witch hunt and persecute Honorable Atufosin when he himself concedes in interactions with Mr. Gyamfi that there is no case for Dr. Atufosin to answer. And he has gone to desperate lengths including committing crimes and breaching the ethics of the legal profession, ethics that governs the work of prosecutors, just to achieve this evil, and wrongful conviction he desperately needs. And so that is also one of the applications. And we're going to see what the court's ruling will be. What is instructive in all this is that Mr. Godfred Yeboah-Dame, the Attorney General, against whom all these testimonies have been given, these pieces of evidence have been given in depositions contained in affidavits before the court. These are sworn statements that Mr. Jakpa, for example, has indicated his willingness to testify to and to be cross-examined upon. And you would have expected this Attorney General to have sworn an affidavit and opposed, dispute or deny these averments or assertions by Mr. Jakpa and Dr. Atufosi. But very strangely, he decided to abscond again. When some of us had cause to raise the fact that when Jakpa's testimony on 23rd May 2024 was given in the witness box during cross-examination, and he told the Attorney General in his presence that you have sought to influence me, you have sought to press upon me to implicate Honorable Atufosi. The Attorney General was there and he could not object. People said that, it's a strategy. He can come back through cross-examination to undermine that and all that. Here you are. Now these matters have been put before the court in affidavits, several affidavits, and you have the right, if you think these allegations are not true. I hear he told you not too long ago that God will speak for him. Well, he can speak for himself, but God helps those who help themselves. But very strangely, he has not been able to swear to any affidavit to oppose to those material facts against him as a person. On the contrary, it is a principal state attorney in his office who has sworn to an affidavit saying that what Jakpa is saying is not true. The Attorney General didn't meet him. The Attorney General has not responded to any of his WhatsApp messages. And the WhatsApp messages are out there. You saw the Attorney General calling him, responding to that. In any case, why can't Godfred Dame speak for himself? Why can't he swear an affidavit and oppose the allegations or the evidential averments made against him by the accused persons? So clearly, this is somebody who knows that there will be consequences if he swears an oath and lies under oath. So he's shifting the responsibility to a principal state attorney to deny for him things that he can deny. That is strange. That is incredible. You understand? And that is why counsel for Mr. Jakpa has raised an objection that in law, that principal state attorney cannot be the one making those depositions, because you can't give hearsay evidence in court. You were not on the call which was recorded by Mr. Jakpa. You were not in the interactions, the meetings that Mr. Jakpa claims to have had with Godfred Dame. And those matters are not part of your work as principal state attorney. And so you cannot say that those matters are in your personal knowledge. You can only testify to matters within your personal knowledge, except under certain exceptional circumstances. And in this case, those exceptional circumstances don't exist. And that is why lawyer Tadia Story was making the point that he's objecting. That's why he was making the point that he's opposed to the affidavit in opposition from the AG's outfits, because only Godfred Dame can say whether or not Jakpa's testimony is true or false. You and I were not there. That principal attorney was not there. And the principal state attorney has even gone to the extent of deposing to matters that happened in chambers when he was not in chambers. You understand? So who is feeding him that information? Clearly Mr. Dame. And why is it that Mr. Dame himself, who is the subject of these matters, if he has nothing to hide, cannot depose to those issues?
Yeah,
why?
His inability to do that strengthens our case.
Whether it strengthens our case or not is determined by the judge. But at least Ghanaians are discerning. There is a public officer paid with our taxes, and serious averments have been made in court, not in the media, against him. He's been quick to deny them in the media. His spokesperson Wilberforce. You understand? and the Deputy Attorney General have issued statements and granted interviews defending him. Now we come to court, you expect this Attorney General to swear an affidavit, to dispute these things, to provide counter evidence, and the man is fleeing from accountability. He can't defend himself. He wants somebody to do that for him. Well, we wait to see what the court's decision will be on all these matters, which I believe will be assessed by the court in arriving at the decision. What I can tell you though is that irrespective of what the decision of the court is in this matter, we as a political party, and of course all well-meaning Ghanaians, will join us to demand accountability from the Attorney General, because he is first of all a public officer occupying a very important role. Our prosecutorial powers as a country have been vested in him. He is paid with our taxpayers' money. He is supposed to do fairness and justice to all manner of persons. And so this is not only matters that are sub judice. These are matters of considerable public interest. And irrespective of what happens in court on these matters, we will pursue these matters to their logical conclusion. We've spoken about a motion of censure and a publicly televised investigation into this matter by Parliament. We are going to pursue that. We've spoken about disciplinary proceedings against him by the appropriate bodies, including the General Legal Council. We are going to take that up. And we've also spoken about possible criminal prosecution. And if it doesn't happen now, well, crime has no expiry date. It will happen someday. Thank you very much.